Good morning, good afternoon, Ms. Anderson. Let me pull up your case here, see what we've got. So it looks like you are a CU student, is that correct?
Yes, I'm going into my senior year.
Okay, so I have, looks like 2 charges. A little bit strange. You got a traffic charge of making an unlawful U-turn, and then a charge of possessing or consuming alcohol by someone under the age of 21. Looks like you now have turned 21. Is that correct?
Correct.
Okay. So let me look and see what the prosecutors have put in the file here. So they're willing to wrap up both charges with what's called a deferred judgment. They would want you to plead guilty to the 2 charges, and then the case would stay open for 9 months. At the end of the 9-month period, the case could still be dismissed. Your guilty plea would be withdrawn to the 2 charges, and your case could be dismissed. You'd be expected to complete an Alive at 25 class, which is a driving class. And then our probation officer would have you complete an audit and determine what type of alcohol-related class they would want you to take. If you did both of those things at the end and went through the 9 months without any criminal charges, then your case could be dismissed and your record could be sealed. So that's one option for you. We don't have a prosecutor here in the courtroom today to discuss any other options with you, but if you would like to have a conversation with one of them, we could reschedule you to come back and have a pretrial conference with one of the prosecutors.
Yeah, I think pleading guilty to the U-turn is one thing, but I had the open beverage in my car as I was the drunk, designated driver.
Okay.
So if someone left a bottle in there, I won't plead guilty to being the minor. I had it in my vehicle. If that's what they mean, then sure, but the consumption and driving, that I will not plead guilty to.
Okay, and you weren't being charged with consumption, driving while consuming alcohol, but it may be worth having a conversation with a prosecutor for you, because they may be able to tailor a different type of plea offer for you. So I would suggest rescheduling this so you could come back. We can Teams them and see if they're able to jump in. Usually on this docket, they're not available, but if we've got someone available to talk to you, I hate to make you come back if we can do that. So Sabrina's going to send a Teams message, and if we've got a prosecutor who can jump in for a conversation, they may want to know, they may look at this and say, well, you are now 21, and with the other facts that you've described as being the designated driver, they might tailor something different for you.
I also didn't know if it says in the file, I did like the full drunk test also. I don't know if it says that, like I walked the line, I did the eye test, all of that.
Right, you did the sobriety.
Right.
I didn't see any updated, aside from what's aside on the ticket.
Yeah.
I have my original slip too.
Yeah.
That they gave to you?
Yeah.
Is that just the ticket?
I'm not sure if it says on there, but I know it says he had like his camera and whatnot, and that's when he turned it on to do the like drunk line and the light and all of that.
I don't show that in the initial case report,
Okay.
but there may be body worn camera evidence that could be secured as well. So let's see what response we get from the prosecutors to see if they're available to talk to you. But I think it would make sense for you to, when you're pleading guilty to a criminal charge, even though it's a possession of alcohol by a minor and not as serious as some charges, it's still pleading guilty to a criminal charge.
Yeah.
So I'd want you to at least have a chance to talk to them if that's what you'd prefer to do.
Okay.
So why don't you just, you can relax for a moment. We'll see what response we get, and I'll call you back up once I hear it.
No problem.
Mr. Altenberg will be able to in about 5 minutes.
Okay.
Which gives me a second to set up the iPad.
Okay, great. And we've got Mr. Altenberg appearing virtually. Mr. Altenberg, if you've got some information to share, I'm happy to hear it.
Yes, Your Honor. I would just like to state that I had a conversation with Ms. Anderson about her case and the offer and file. Just provided her some background information about what exactly is required about the DJS generally and how it would or would not affect her record. For the purposes of this DJS in particular, Your Honor, because it is a case involving a U-turn prohibited and an MIP in which she was the designated driver and there was liquor in the vehicle from other individuals. We did try to, I did reword the DJS to specify that any future cases that may be in violation would be specifically under drug or alcohol offenses, because that is the focus here in terms of the DJS. Aside from that, I do have one question to pose the court, and that would be whether or not you would request the city's attorney's office to provide Ms. Anderson the Alive at 25 course information, or is that something that would be provided by probation alongside the other information?
So yes, if Ms. Anderson decides to accept the agreement, we'll provide the Alive at 25. The only time we ask you to do that is if you're doing something where you're going to dismiss prior to the next court appearance. But if it's going to be part of a plea and then probation or monitoring from the court, you don't have to worry about providing the information. We would provide it.
All right, thank you, Your Honor.
All right, thank you for that, Mr. Altenberg. So let me just pull that offer up. So Mr. Altenberg said he had reworded it a little bit. And then you get to decide at this point how you'd like to proceed, Ms. Anderson.
Yeah, and I fully will be okay with doing the Alive at 25 and the driving course. I'm okay with both of those.
Let me make sure I'm reading this, because it wouldn't be just a driving course. It would be, you'd have a substance use screen.
Right.
And the Alive at 25 is the driving course.
Substance abuse screening, that's the one thing that we hadn't gone over.
Yeah, so our staff, our probation officer, if you decide to accept the agreement, and that's still something that you haven't yet determined, but if you decide to accept the agreement, you'd be pleading guilty to possession of alcohol by someone under the age of 21, and you'd be pleading guilty to making an unlawful U-turn. Neither of which get reported onto a database because we would be keeping the case open for 9 months.
Right.
But you would have to do the Alive at 25 class, and then you would meet with our probation officer. She would have you complete an audit, or basically a screen of your alcohol use.
Okay.
And then she would determine what class for you to complete.
Okay.
Since you're a senior at CU, it's likely that she would pick a class that you would be required to complete through the university. So,
Okay.
and I'm blanking on the name of the health promotions. Health promotions at CU puts on these classes. So she would direct you to complete one of those classes through CU, and then you would provide proof that you had completed that class.
Right.
All right. So I'm not suggesting one way or the other, but if you want to accept the agreement, you could do so right now.
I'm down with accepting the agreement. Thank you
Okay,
very much.
good enough. So let me go over some questions that I have to ask every person who enters a guilty plea in a criminal charge, and that's the minor in possession of alcohol is considered a criminal offense. When you plead guilty, you're giving up your right to trial and all those other rights that I described for you and the other young man a few minutes ago. Do you understand that?
Yeah.
Are you doing that voluntarily?
What do you mean?
Is anybody forcing you to plead
Oh,
guilty?
no.
All right. Are you under the influence of any medications or drugs or alcohol today?
No.
And do you understand this charge of being a minor in possession of alcohol?
Yes.
Do you agree that there's evidence to support that charge?
Yes.
You're doing this without the benefit of consulting with a lawyer. I'd be more than happy to continue your case over if you wanted to contact a lawyer, and you could actually get one through the university at a pretty reduced fee. So if you wanted to have a lawyer give you some legal advice, we could continue this over. So that's an option for you.
Okay.
And I want to make sure you understand that option before you make your mind up. And you look like you're pausing a little
I'm
bit.
just curious as to what they could possibly do in this situation, just because the U-turn is already there. There's just really nothing. I don't know what they'd advise me for, maybe a different agreement, but
they might represent you and say, hey, yes, you may have made an unlawful U-turn, and that would be one way to resolve that part of the case.
Okay.
But they may take another tack with respect to the plea of guilty on the minor in possession of alcohol charge. So I can't give you legal advice as a judge, but you could certainly consult with them. And the other judge who works in our court used to work for that very department. She was the lawyer for, 20 years at the University of Colorado's program. And so we've had long discussions about what she did in her capacity, and she would often advise people who came into our court and sometimes she would come and represent them in our court. So I'm not saying you should or shouldn't, but I just want to make sure you're comfortable.
I'll take the agreement. It's a 9-month thing. I can do it easily, and I don't want to drag it on any longer.
That's perfectly fine. Sometimes people make that choice as well. So as I was kind of working through, so you're comfortable moving forward without the benefit of counsel, and you understand a lawyer might do a little bit better job of representing than you do representing yourself?
Yeah.
Okay. And you are a CU student, so I'm going to find that this is a free and voluntary decision to plead guilty. Let me go ahead and accept the guilty pleas. And we'll start with the charge of making an unlawful U-turn, which is a violation of section 7421 of the Boulder Revised Code. This allegedly occurred June 15th of 2025 at 30th and Baseline Road. How do you plead to that charge?
Guilty.
accept the guilty plea for Sabrina's purposes because we don't report this to DMV. So we're accepting the guilty plea, but we're deferring it. So there's no real action as far as sending anything down to DMV.
Yes.
And then, so I've accepted that guilty plea. Count two, or the other charge is a charge of possession of alcohol by someone under the age of 21, a violation of section 574 of the Boulder Revised Code, also from June 15th of 2025. How do you plead to that
I
charge?
was guilty as well.
All right, I'll accept the guilty plea. We'll place you on the deferred judgment for both counts for the 9-month term. I'm going to have you meet with Fernanda here in just a moment. She's going to go over your alcohol use with you. She'll probably have you fill out an audit, and then she'll talk to you a little bit further about that and determine what class for you to complete. And then she's also going to give you information about the Alive at 25 class and give you a deadline for completing that. She'll give you an internal review date. As long as you get proof to her that you've completed those things by the date that she sets for you, you won't have to do anything further except go through the rest of the 9 months without any other criminal charges. There's a total of $155 in fees and costs that are required as part of the deferred judgment.
155?
That's right. Are you able to pay those today?
Yes, I should be. I'm gonna call my dad after this, if that's okay.
That's okay, sure. And I'm going to just put a note here. If defendant needs time to pay, that Fernanda can give you time.
Okay,
If you can't put something on a credit card or a debit card, then we'll just give you a deadline by which you have to pay the fees. And if there is a request for that stay, I'll waive the stay.
and then would I do that online if I do it like later today or tomorrow or
Yes,
whatever?
she'll talk to you about that.
Perfect.
All right, I think we've covered everything in pretty good detail. Do you have any questions for me?
No, I think that's it.
All right, so we're going to send you down to see probation. So you'll make
Great.
2 rights and then a left down this way. Fernanda will be there to meet with you in just a few moments.
Perfect, thank you.
You're welcome.
Well, that took a turn. Watching in this docket was like watching someone teach a live seminar on deferred judgments, careful to explain every right, every condition, and every option while still keeping the train moving. The headline case was Miss Anderson, a CU senior facing 2 charges, making an unlawful U-turn and minor in possession of alcohol. By the time of her hearing, she was already 21, and she explained she'd been the designated driver when the open container was found. Cahn didn't push her into a plea right away. Instead, he suggested she speak with a prosecutor, who appeared virtually and confirmed the offer, a 9-month deferred judgment on both charges, paired with an Alive at 25 driving course and an alcohol use screening through probation. Successful completion would dismiss and seal the case pushed back on pleading guilty to possession, insisting she hadn't consumed alcohol, but listened as Cahn carefully laid out her choices. He stressed that even a minor in possession charge is still a criminal offense and reminded her she could consult CU's legal aid program at low cost. After weighing it, Anderson chose to accept the deal. Guilty pleas to both counts, deferred for 9 months. Cahn walked her through every waiver of rights, trial, counsel, confrontation, appeal, and confirmed her decision was voluntary. He mechanics worked. Neither charge would be reported to DMV during the deferral. She'd pay $155 in fees and costs, complete Alive at 25, and finish whatever alcohol-related class CU's health promotions office assigned after the probation screen. Proof to probation by the internal review date meant no further hearings, just 9 months of staying out of trouble. He even reminded her about practicalities, deadlines, online payment options, and what to do if she couldn't pay immediately. What stood out was, he wasn't just moving cases, he was teaching. He explained why stand-in pleas like defective headlight or deferred judgments work, highlighted the difference between dismissals and sealed records, and made sure a nervous student understood exactly what she was agreeing to. His courtroom felt less like a punishment mill and more like a structured civics lesson, one where accountability came with clarity and even a little reassurance. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.